This is News 24 Live. I'm Erin Bates. Thank you for joining us. We're going through the Nkandla judgment, and with me in studio is Pierre de Force, who's a professor at the University of Cape Town's Law Faculty and has a specialization in constitutional law. Pierre, thank you for your time. If we look at this Constitutional Court judgment, it clarified a number of things in a way and set a precedent. What does it mean in terms of constitutional law in South Africa?
Well, it sets the precedent in the sense that it clearly states what the obligations of the National Assembly is in holding the President accountable. So if there's a finding, for example, by another body like the Public Protector, the National Assembly has to take that finding and they have to use that as the basis for holding the President accountable. Although the court didn't say exactly how that has to happen, because they said this is not for a court to decide. It also said and made clear for once and for all that the findings and the remedial action imposed by the Public Protector are in fact binding, and that you cannot ignore them. If you want to second guess them, if you think they are wrong, you can go to a court and have them set aside by a court of law. But if you don't go to the court and have it set aside by a court of law, you have to comply with them if they are of the nature that are binding.
So if we go back to when President Jacob Zuma asked the Minister of Police to look into Nkandla, if the Minister of Police had an understanding of the constitutional law that was maybe more thorough or based in fact on the judgment that we only have now, could he hypothetically have said, actually, that's not my role. We need to follow the Constitutional Court's rules and we need to follow the Public Protector?
Well, the Constitutional Court was clear in saying that it wasn't impermissible, say, for anybody in the executive to look into the Public Protector's report with a view to decide whether it should be taken to court and challenged. So that would have been the appropriate thing to do, to say, okay, let's have a look. Maybe the Public Protector made a terrible mistake, in which case, if we find that, we're going to take it to court and ask the court to set aside this whole report. But that didn't happen. They tried to say, well, we don't like this report, so we make our own report and we invent a fire pool and the rest. And on that basis, we are going to exonerate the President, while that could not possibly happen, said the Constitutional Court. So that was a mistake. Why it didn't do that? I don't think it could be because of, on the one hand, because of a lack of understanding about what the Constitution requires. On the other hand, he would have been very dumb to do that, because he would have then implicated his boss, the very person who gave him the job and can also fire him. So if he wanted his job, he probably wouldn't do that.
And history kind of speaks for itself on that one.
Yeah.
So really, in terms of what the Public Protector said in Secure and Comfort, that ship has sailed. There's no time now for President Jacob Zuma or anyone in the National Assembly or indeed his lawyer to say, well, we're actually not sure about this one, or we think the Public Protector and OT might have overlooked that. That opportunity to follow a legal sort of query or quibble over the report has come and gone.
Well, there is there's a certain period of after which one cannot launch a court case. So I'm not exactly sure what that period is. But given on the political front, given the fact that the President has already conceded before the Constitutional Court that he is going to be bound by the Public Protector report, that he agrees with the findings now, I can't imagine that it is possible, even if that time of prescription hasn't elapsed in the meantime.
Yeah. You have, in anticipation of the judgment, written about the question of impeachment, something that President Jacob Zuma lawyers raised as well. Really, it's not something that's the ambit of the Constitutional Court.
No, the court cannot order the impeachment of the President. The Section 89 of the Constitution says that the National Assembly may pass a vote of impeachment, if you will. They don't use that exact terminology. If there was a serious breach of the Constitution or the law by the President, if the President is incapable of doing his job, or if there's serious misconduct on the part of the President. But that is not a peremptory power, so it's not as if they are constrained and they have to implement or pass a vote impeachment proceedings against the President. If there is a finding that the President is in serious breach of the Constitution or the law, they may do so, says the Constitution. So they are allowed to do this. So it depends on the politics. So if people are going, some people might get upset If they don't do this, and what they must be upset about is, obviously, if they are the kind of people who will be upset by this, by the political party who decided, no, the governing party, we are not going to go this route. We are going to instruct our members of the National Assembly not to remove the president from office, because that is the decision that is taken. It has nothing to do directly with the Constitutional Court.
But they really handed the baton of the judgment to the Constitutional Court. And if we look at what Zizi Kodwe from the ANC said today, really kind of put the brakes on and said, we'd like to study this pretty comprehensive document and then issue a statement.
Yes, well, obviously, the impeachment proceedings can only happen if there's a factual situation is proven, if there is a serious breach of the Constitution or the law, for example. So that is the first requirement. And then the second requirement is that the majority party and 2/3 of the members of the National Assembly, along with them, must want for there to be an impeachment. We don't actually know how the National Assembly will find whether there was a serious breach of the Constitution or the law, because in the present circumstances, there is no rules in the National Assembly providing for this process. Yes, so we don't know. But in the meantime, it is for the National Assembly, obviously, to see what they think about the judgment. And they might argue, well, there's nothing untoward or strange for a court to find that there's that the president or the National Assembly, for that matter, is in breach of his constitutional duties, because that happens quite a lot. It's not the first time. But what is different in this case is that the breach was found to be related to the president having a conflict of interest in which him and his family would be enriched by the effects of the mismanagement and the conflict of interest. The president was required to take steps to make sure that people would not drop his name and build him a swimming pool called the fire pool and so on. And he didn't do that. And it benefited him. It wasn't a normal political mistake that a normal president might do in maybe not fulfilling a constitutional duty because he was legally unaware of what the right option was in the circumstances.
So it's really that conflict of interest between him and his family's benefit and his duties as the head of a constitutional democracy.
Yes, so that is what the public protector also found. She said in terms of Section 96 of the Constitution, when there is such a conflict of interest or the perception of such a conflict of interest, if you're a member of the executive, you're not allowed to expose yourself to that. The president, said the Constitutional Court in its judgment today, clearly acted in a way that exposed him to this conflict of interest by having private renovations done and then the security renovations at the same time in a context where he must have known that people are going to want to give him some benefits and put some extra frills and a swimming pool here and air conditioning there, and he should not have allowed that. And just for allowing that, that is a clear breach to his own benefit, unlike a normal kind of breach of the Constitution in inverted commas, which is just of a political nature and not about, it doesn't look like self-enrichment as this one does.
If we look at the judgment itself, it's the thinking and argument of 11 legal minds, you know, the real kind of top brass of our legal fraternity in South Africa. How careful do you think they were in terms of the language? For instance, not stating overtly, President Zuma did something that was absolutely unconstitutional and is completely intolerable, and kind of playing into political rhetoric almost, that it was beginning with the Constitution, how it was formed, the drafters of the Constitution in South Africa, and the kind of measured way in which it went through to the final judgment and those numbered points.
Well, that is what the Constitutional Court is supposed to do, and that is what they usually do. They write judgment based on law in relatively measured language, in which they just describe what happened and what ought to have happened and what the problems are in that particular case. And this is exactly what they did in this particular judgment. They were also, they didn't really engage in the question that they were invited to engage in by some of the counsel before in the oral arguments, to say that there was a deliberate flouting of the constitutional duties by the president. They said, well, maybe the president was mistaken because of the High Court judgment. Maybe he didn't know that this was binding on him, and so he flouted the public protector findings and remedial action when he shouldn't have. So they left that open. They didn't, because they probably decided that there was not enough evidence before them to make such a drastic finding.
So that judgment doesn't say whether it was, in terms of the neglect of his constitutional duties, a sin of omission or commission?
For me, the bite of the judgment is not so much in the finding that the president acted unlawfully by flouting the public protector's report and not complying with the public protector's report. It is the confirmation in that judgment that the president had actually previously, as found by the public protector, flouted Section 96 of the Constitution by allowing himself to be in this position where there was a conflict of interest. That is what the public protector found. She found that he didn't comply with his constitutional duty. The Constitutional Court now confirmed this in today's judgment. And that is far more problematic because the second issue about flouting the public protector's report, one can still argue maybe we were not sure about the law. The Constitutional Court had not yet said that the public protector's report and findings are binding. But on this first issue about a conflict of interest, of not protecting the resources of the country, of not protecting the integrity, impartiality and independence of the public protector herself by not complying, for example, with the request on her part to provide him with information, and the relevant documents, that for me is far more scathing than the second question.
It does also raise a question around the legal counsel that sort of, and likely, engaged with President Jacob Zuma and with his assistants and came up with the argument that went to the Constitutional Court. Is it likely that there was an absolute vacuum of legal minds around him in all the years of deliberations in the National Assembly and indeed the Public Protector's research into the Nkandla upgrades?
This is always a challenge for legal advisors to very powerful and influential people. And that challenge is, am I going to tell my client what they need to hear and what the law actually says, or am I going to tell them what they want to hear? Sometimes people get also personally invested in the matter. One of the president's lawyers is Mr. Hali, who has come a long way with the president. They are very entwined. Their relationship, their financial affairs, it's entwined. So in that context, it is not always easy to keep a clear head and to provide advice that is actually based on a clear-headed understanding of the law and not on an emotional understanding of what you hope the law might be.
And what will please your client. I suppose what also changes now is that because the judgment has been handed down and clearly stipulates the authority of the public protector, that any legal counsel to a future president, or indeed our current president in future, can refer to that document and say, there's no quibble here, what the public protector says is serious and we need to either dispute it through a legal procedure or follow the recommendations.
Yes, and it's important both for the executive and the president and for the National Assembly and Parliament, because the Constitutional Court was very clear on both accounts that the president or a member of the executive or anybody else for that matter who is going to be found to be infringing on some law or found to have acted in a way that is guilty of maladministration or whatever, and where there's remedial action imposed, that is now binding. That is clear. You have to follow it, otherwise you're going to be second-guessing the public protector, you're acting unconstitutionally and unlawfully. For the National Assembly, they have to hold the executive accountable based on that findings made by the public protector. If they don't like those findings, they can go to court, but if they don't go to court, they have to do something. we are still not sure what
What?
they're supposed to do.
It's a big looming question, that what? And in terms of the National Assembly, is certainly hopeful that members of it are poring over Mogoeng's judgment on behalf of the 11 judges in the Constitutional Court. Stay with News 24 Live. We'll be back shortly with more from Pierre de Vos of the Law Faculty at the University of Cape Town.